The third deadliest mistake that companies make is that they fail to turn their credit application into a credit contract. Let me explain. When someone asks you for credit, you are in an ideal position to get a credit application signed. In a few moments, we will discuss what to do with that credit information, but right now I'm talking about something differently. I'm talking about putting every safeguard you could imagine into your credit application. You could put the wording in your credit application that gives you permission to file that unsigned UCC1 form that we just talked about in the last section. You could also include a clause about legal jurisdiction in plain English, so if a company fails to pay as agreed, they agree that you can sue them in your county and in your state, regardless if they're in your state or if they're clear across the country. You also want to be able to charge collection and attorney's fees if the account goes into litigation. You also want to be able to have the ability to charge finance and late charges. If you do not have a signed contract, you cannot charge back any of these items to your client. Even if it's on your invoice, the debtor must sign, and you absolutely have to have their signature agreeing to your terms and your conditions. You also want to have a liquidation clause in there in case they hire your temporary. In plain English, if they hire your temporary, then they agree to pay you X for that person. A credit application is a perfect place to put all of these safeguards for many reasons. It puts your client on notice that you're serious about your credit and your collections and about getting paid. But more importantly, a lot of these clauses will get buried in the back and will go unnoticed. A credit application is a wonderful place to put the personal guarantee that we talked about in the very first section. Just remember to have it in its own area and to make sure whoever signs their name, they do not put their title anywhere near the personal guarantee section. Let me make a quick clarification on these safeguards. I have had clients call me from time to time and they say, my contract calls for collection fees and attorney's fees and late fees, and I want you to collect them as well. The only way that we can physically force someone to pay those fees or to sue them, get a judgment, and then try to enforce that judgment, it would be very expensive for you. If a debtor owes you $10,000 and they offer to pay $10,000 now but not the collection fee, I will always recommend that you take the $10,000 now, because if you have to file suit even for $13,000, which would include the collection and court cost, it would take about 12 to 18 months to get it before the courts. Then you still have to try to collect it if the company is still in business. These safeguards are wonderful if the account goes to litigation, but they're also a very good negotiating tool if the account comes to us or anyone else for collections. We can negotiate the late fees and the attorney's fees and keep the principal amount intact. A word of caution on the credit application. Make sure whoever signs a credit application has perceived authority. If it's a manager or a president or an officer that signs the application, then we can enforce the contract. But if it's a secretary or a temp or the janitor, the application then would probably get kicked out by the courts. They would still owe the principal amount on the invoice, but they would not owe all of the extra finance collection fees. So let's grab a pen and let's recap what you want to have in your credit contract. First, the ability to charge finance charges. Second, security statement so you can file that UCC1. Third, the jurisdiction is in your county. Fourth, the ability to collect attorneys and/or collection fees. Fifth, liquidation fees if your temporary is hired, and a place for the personal guarantee.